Good morning and welcome to an oral argument session of the 5th District Court of Appeal. We have one case set here at 11 o'clock today. I have joining me on this panel, Judge Dan Traver and Judge Mary Nardella. The case is Felix versus National Collegiate Student Loan Trust. And I'm going to assume, Mr. Pierce, that you want 5 minutes for rebuttal unless you tell me otherwise. And yes, you may just ask that counsel make sure you have any noise-making devices muted. And otherwise, when you're not speaking, if you'd please put your microphone on mute. And Mr. Pierce, you have the floor.
May it please the court, Carlton Pierce of Carlton Pierce, PA. I represent the appellant, Kadir Felix. This is a case where it comes back to a motion to amend. In Florida, there is pretty much an absolute right to amend unless there is clear evidence that there has been prejudice, abuse, or futility. In this case, none of the aforementioned occurred. More specifically, this case is very similar to Crown. For example, Mr. Felix filed a pro se answer. That was the same thing that happened in Crown. In the case of Crown, it was idle for 7 months. In this case, it was idle for 16 months. As far as the motion for summary judgment, when it was pending, in Crown, it was 21 days. In this case, it was 60 days. The motion to amend in Crown was filed 14 days before the hearing. The motion to amend in this case was filed 12 days before the hearing. Neither case, whether Crown or this one, was set for trial. It was the first time amending in Crown. It was also the first time amending in this case. At the hearing on the motion for summary judgment, the issue of prejudice did come up, and it was in reference to whether or not the motion for summary judgment could be heard. That is not the type of prejudice that is spoken about in the case law. Specifically, when you're talking about prejudice, you're talking about the person's ability to prepare for the new argument or the new defense. There was no argument that National could not prepare for the new arguments and the new defenses. Moreover, they had to be aware of them because although Mr. Felix filed a pro se answer, the pro se answer did have some of the elements of what was brought up in the motion to amend and the attached amended pleading. Also at the hearing, the trial court seemed to say that abuse occurred because it was very short. It was very close to the time of the hearing as far as the motion to amend. Again, the motion to amend was filed 12 days in advance. And also the court said—
could you just address the fact that it wasn't noticed for the hearing?
Yes, Judge, it was. The court said that it was not noticed. It was noticed. I filed a notice of hearing. The court's position was it wasn't properly coordinated with opposing counsel. I sent an email to opposing counsel, trial counsel, because appellate counsel is not trial counsel. And the trial counsel did not respond. And then what happened after that, it was 3 days before I went ahead and filed the notice of hearing. I knew the time was reserved, so they couldn't say that they were unaware that the hearing had been noticed. The court's position was it was not properly noticed and it wasn't coordinated.
Mr. Pierce, unfortunately, the video kind of froze up right when you were getting ready to say something.
Sorry.
Can you clarify? I guess my question, I think, is in line with what Judge Traver is asking. The motion to amend was done within, 2 or 3 days prior to the properly or fully noticed hearing on the motion for summary judgment. Is that correct?
No, it is not. The motion to amend was filed 12 days prior to the hearing. The notice of hearing was filed 3 days prior to the hearing.
Okay, and the notice of hearing, was that coordinated between counsel, or was this in can occur in past litigation experience where a party notices it, but they notice it out of frustration for a lack of coordination to set the hearing?
I wouldn't say it was frustration. What happened is I attempted to communicate with opposing counsel by sending an email to determine whether or not he had an objection to the motion to amend. I did not get a response to that email 3 days prior. I looked on the judge's website and the judge's website did not have the method of clearing it through her judicial assistant. Every other judge that I looked on in that section, they did have instructions. So I went ahead and I noticed it, and that became an issue at the hearing. But although that was an issue at the hearing, I also requested an ore tennis motion to amend. Now, she didn't specifically deny that motion, but of course, with the order, it was denied because she denied the motion to amend. Hopefully that answered Judge Traver's question.
A little bit. I'm just looking at the time frame. It looks like you filed June 19th at 7:12 p.m. your notice of hearing. June 19th is a Saturday. And then the hearing looks like it happened at 11:15 that Tuesday morning. So it looks like if we look at business days, it was far less than 2 days notice.
I would agree with that.
Okay.
I would agree with that. However, when you look at the motion to amend, again, there was also an ore tennis motion that was requested. And again, there is definitely no clear evidence of prejudice, abuse, or futility. Now, again, the prejudice, as far as the court and national were concerned, it was based upon whether or not they would be able to complete the summary judgment hearing. And they both said that. And realistically, when you look at what national said, national was very well aware of the fact that I had the right to, my client had the right to amend, because national even stated, well, I know that he has the right to amend, but the timing is just a little off. Well, if he knew that my client had the right to amend, there should have been a full stop right there. Because if you have the right to amend, you should stop and say, okay, well, let's go ahead and do the amendment. Because in Florida, of course, the policy is to resolve things on the merits. And in this case, resolving it on the merits would have simply meant granting the motion to amend and then going through the elements of what those pleadings would bring about. Now, when the judge asked, well,
if we assume, and let me just ask you, Mr. Pierce, how this would look like in print. If we assume that you didn't comply with the trial court's guidelines for getting this properly noticed, and look, we've all been in the situation where we're trying to piggyback things on other motions, and I think trial courts understandably have methods to deal with that. Otherwise, you just completely run out of time because everybody's doing it. So if we accept for a second, and I'm not saying that you do, but if we accept for a second that this wasn't properly noticed for it to be heard at 11:15 on June 22nd of 2021, are you asking us basically to write an opinion that says that as a matter of law, if you ore tennis notice it or ore tennis make the motion during that hearing, the trial court always has to grant it?
no, that eliminates the discretion of the trial judge. I would never ask that. What I'm stating is that we're looking at the long history and the case law addressing it. I really don't think that there should be.
Isn't the trial court's discretion effectively already eliminated by the long body of case law that says that you get one free bite at the apple?
Unless there's a clear demonstration of prejudice, abuse, or futility. If that's demonstrated, then the trial court does have that discretion. But Crown and all the other cases related there too, and in every district, they all say the same thing. There must be.
Crown seems different in this case than this case, though, just because of the procedural posture, in the sense that it seems like the Crown, that motion was properly noticed.
Well, yes, there is a little bit of difference there, but as far as the difference is concerned, again, you look at the case law and the full body of it, and the fact that there was that ore tennis motion that was made, and the issues that was presented there. And now it's just not the motion to amend that made the summary judgment improper. I haven't gotten to the other parts because there was a conflict in the evidence. And then, of course, there were damages, unliquidated damages that were awarded. So there are other issues. Discovery was ongoing. there are other issues there that made summary judgment improper. But the motion to amend, from my client's standpoint, obviously should have been granted. But even if the motion to amend were not granted, summary judgment should not have been entered based upon the clear case law for summary judgment.
Mr. Pierce, getting to that question now, you've made an allegation, and I guess this is what you're saying is your genuine issue of material fact, that in general, payments without showing any credit for those payments create the issue of genuine fact. You're not, I guess you're taking the position that you're not required to specifically indicate to us how those payments were insufficient or what's the exact amount that they were insufficient for?
I don't think I'm quite, I'll answer it this way, and I think that I'm following the court, but I'm not quite sure. As far as the inconsistencies, Judge, we're talking about 85 payments that were made from March 8th, 2013 to December 25th, 2015. There were no credit given for those payments. The responsibility of calculating how much is owed, that is up to the moving party. So that would be up to the appellee. And that was one of the problems as far as with unliquidated damages. There were no calculations that were made, and that dovetails into the discovery issue. Part of what was requested in the discovery were the documents to prove up those numbers.
But counsel, just to be clear, your argument isn't that no credit was given. Your argument, and correct me if I'm wrong, is that no credit was given to the principal balance.
Through that time period, there was no credit given at all. I'm just looking at the documents that were there.
So your argument is you can't tell if there was credit given to the principal balance or alternatively to the interest.
Correct.
Because was a loan made in 2006, and payments didn't start until 2015. So we have a loan which for approximately 7 years before any payments ever made.
Yeah, it was a school loan.
Right.
Right. No, I fully understand that. But the issue is that if you're making payments, there should have some impact on some balance, and there's nothing there. And that is exactly why that was requested in the request to produce.
I mean, the interest doesn't go up either though, right? I count 77 payments as opposed to 85, but be that as it may, the interest doesn't move either. And if you actually calculate up the totals, the interest moves more than the principal. So I guess to Judge Nardella's question, why would the principal drop?
I don't even know what at a particular point, what is the principal, what is the interest? Because as I stated also, there was not a logical pattern to the interest. Now, the principal, of course,
sometimes it was 3 months worth of calculations on LIBOR. Sometimes it was 1 month. I'll grant you that transaction history is the furthest thing from a model of clarity. But I think the overarching question is, under the new summary judgment standard, did your client have any additional obligation to say something more than, hey, this doesn't look right to me?
No, I think that in that case, I think that's, as I argued in my reply brief, there's burden shifting there. Now, as far as the discovery issue is concerned, when that is pointed out, not only that, all right, well, we'll stick with as far as the numbers. When that was pointed out, and especially since the interest did not post until 3/14/2016, those are issues of material fact. When the interest allegedly accrues in 2013 and it doesn't post until 2016, that in my eyes anyway, that's a problem.
Well, I mean, if you've got under the new summary judgment standard an affiant who's saying the amount owed is this, and all you come back with and say is, I'm not sure that's the amount because these things are wrong. I don't necessarily know, and correct me if I'm wrong, but I don't necessarily know if your client meets his burden under the new summary judgment standard. He may well have done it under the old one.
No, I'm saying that it's not accurate because I'm saying it is not accurate because it's not mathematically calculable. That's the requirement.
Does it have to be? I mean, if the affiant just says, this is what you owe, doesn't the burden shift to your client to say, no, that's not what I owe because I made this particular payment on this particular day?
No, actually, Judge, when you look at unliquidated damages, you have to be able to calculate it. And that's specifically what the case law holds, is that anytime, and that's the difference between liquidated and unliquidated. Of course, I know the difference between liquidated and unliquidated is, of course, it has to be able to be calculated. And there are no calculations there. There are no charts which shows anything. In that case, those were clearly unliquidated damages. If for some reason if I were presented liquidated damages, well, I think I'd be able to attack that rather easily. But I wasn't presented liquidated damages. I was presented unliquidated damages. And I went through the chart, I looked, I did not see that consistent, I didn't see any consistent numbers where I could do a calculation. And the case law is so clear. The only thing that I think her name is Jeffress, yeah. The only thing that Jeffress said is, this is the number that is owed, period. No calculations. The court didn't make any calculations. There were no calculations in the LFA. There were no calculations anywhere whereby a determination could be made as far as how my client owed that amount of money. And it's required. They have to be able to demonstrate that. If they're claiming damages, they have to be able to demonstrate that. Now, as far as the discovery is concerned, the discovery dovetails back to the motion to amend. In the motion to amend, there was certain information that I wanted to find out whether or not they could prove up the issue of, well, excuse me, actually defeat my client's claims in his amended answer. Well, with recoupment, obviously there can be an offset, recoupment and set off.
So on your TILA claim, what do we make of the fact that this was a 2006 loan and the Higher Education Act wasn't passed until 2008, amending private educational institutions' obligations to disclose?
Yes, that was 2008, but it was under 2006 and it still applied. And I do believe that I sent the entire statute to the court. I sent everything it was in my reply brief. And that was in effect at the time. So it's not as if student loans would just fall out of place and say, okay, well, this doesn't apply or it goes away. So they still fall under that activity. So they would still have to give that disclosure prior to, not after. It was still a loan, and it still fell under the statutory provisions. Was there? Oh, okay. Now
you're well within your rebuttal time. So
yeah, I was looking at. Thank you, Judge.
Okay, you're gonna reserve.
Yes, I'm going to reserve.
Okay, Mr. Roth, you may proceed.
May it please the court, Brian Roth on behalf of the original plaintiff and appellee herein, National Collegiate Student Loan Trust 2006-4. Based on the court's questions, I think that that the court perceives what the fundamental issue here is. I would suggest, first of all, that based on the record evidence, that summary judgment was unquestionably warranted in the circumstance. So what we have here, though, is an argument that, but what if this may have gotten in? Then perhaps summary judgment might not have been appropriate. But that is putting the cart before the horse. Here, we have a circumstance where did the judge abuse her discretion in not considering the motion for leave or the substantive aspects of that motion, but did she abuse her discretion in managing the docket in that deciding the motion was not even before the court? That, to me, is the question on appeal. And as to whether, if the court did abuse her discretion in this circumstance, given the timing that the court is obviously familiar with and as discussed by Mr. Pierce, given that timing, if this court should determine that it was an abuse of discretion by the judge not to even permit this last minute motion for leave to be before the court, well, then I think we all go back down. If it was not an abuse of discretion, then I think the case is over, because the record evidence quite plainly establishes, we believe, that NCSLT, National Collegiate, was entitled to summary judgment based on the record evidence. And the court went briefly discussing this issue of liquidated damages. And
Mr. Roth, let me ask you a question. I mean, this case
Yes.
has been pending for a couple of years, correct? And it sat idle on the trial judge's docket until the trial judge set it for a status conference and required the parties to indicate why the case had not been resolved. It was prior to that, then that was then when you decided, or your client decided, to notice the motion for summary judgment. But I guess my question is, if you assume when you file a motion to amend, as Judge Traber said, it's at least one shot. In this case, are we rewarding behavior for ignoring request to notice for hearing a motion to amend when the party should arguably at least have that one shot? And then are we also kind of turning our heads when there was no finding of prejudice, abuse, or futility made by the trial judge in this case? I know that's a compound question, but give it a shot.
Thank you, Judge. Yes, and let me take the latter question first. I don't believe that the Crown factors are even a consideration. We didn't get to that point. It is a purely docket management issue. And this trial judge, who has plenary authority over the management of their docket, decided, I'm going forward with the noticed and briefed and the summary judgment that's already before me, and I'm not going to be considering this last minute motion to amend. And so that addresses the latter. Insofar as whether the case, I forget the exact time, but and I'm not collection counsel and I wasn't handling it, so I'm not privy to why the case sat on the docket. But at the same time, I can't imagine that NCSLT wasn't well within its rights to re-urge summary judgment, which had already been previously granted and undone once, why it shouldn't have proceeded with that. And then at that point, it's not incumbent upon NCSLT to do what's necessary to oppose the summary judgment in a timely fashion. It's incumbent upon the opposing party. So I don't think—
I wonder if my colleague's question wasn't a little bit different than that, in the sense that, are we rewarding trial counsel's behavior for ignoring a conferral request that, whether it was agreed to or disagreed to, and maybe there was an error in failing to just set it up and follow the trial judge's procedures? I mean, we'll have to address that. But separately, are we rewarding the behavior of trial counsel and just ignoring a good faith request to confer? Because if he'd have said yes, then the summary judgment hearing is canceled. If he'd have said no right away, then maybe Mr. Pierce notices up in compliance with the trial court's procedures, and it has to get granted at that point, right?
Well, look, I can't speak to whether trial counsel actually ignored this. I mean, quite possibly he never received it.
Let me ask a slightly different question then. If it had been properly noticed up before the trial court, do you agree with me it would have had to have been granted?
The motion for leave, it would have had to be considered. I do not agree it would have had to been granted.
What basis would there be to deny a first request for a motion to amend a pro se's answer?
Well, reminding the court, this pro se has been represented on 2 occasions and was represented at this time. But I would suggest then, at that point, we would have presented evidence of futility, because the amendments offered in defense of or would be offered in defense of the summary judgment are futile. they're not maintainable. But that was never gotten before the court.
Mr. Roth, you said the appellant was represented twice. The last time was because counsel came in an attempt to get the summary judgment withdrawn that was improperly entered in the first place. Is that correct?
I wouldn't suggest improperly entered. Apparently there was an affidavit submitted by the appellant that the court didn't see or didn't review. I don't know the details of that, but yes, the summary judgment was set aside, and then counsel for appellant withdrew. And then once the new motion for summary judgment was set, counsel for appellant entered a new appearance.
Same counsel, correct?
Your Honor, I'm sorry.
Same counsel?
Counsel Pierce.
Yes.
So that's what I meant by on two occasions. So I was just, the court had asked whether this was a pro se plaintiff. I don't know if that's a fair characterization.
A substantial time, I mean, if you just go on the dates, a substantial amount of time that this case was alive, is the counsel was pro se, or the appellant was pro se. Is that correct?
During the period where there was no dispositive activity, that is correct.
What do we make of your client's affiant's affidavit and the exhibits to that affidavit, which, charitably speaking, may not make a lot of sense? How does your client meet summary judgment burden under the new rule by saying that the amount owed is X when perhaps the exhibits that support X don't show X?
Well, my first comment to that was I believe they do show X.
Well, for example, $7,000 of interest is requested in the affidavit, and then under Exhibit H, it's $10,000 of interest. I can't tell where $7,000 comes from, for example. So at what point, if any, does your client's sworn statement that the amount owed is X get defeated by the documents on which she's relying?
Well, my first answer to that would be if there's any contrary evidence presented that suggests that it's not right, as opposed to it just doesn't look right. I mean, here we have the affiant didn't just say, this is how much is owed. The affiant attached and produced records of the running balance of the loan history throughout time. And I just cannot see how this could ever be construed as an issue over unliquidated balances. These balances are readily liquidated. And they've submitted documents that show the running balance and arriving at the numbers. I don't know what
the principal amount appears in two places. It appears in what looks to be a charge-off amount in Exhibit E, and then it appears almost like as an ipse dixit, Latin for because I said so, in Exhibit H. I don't see how that balance is. In other words, you don't see, for example, in the affidavit that the initial balance was X. We calculated over these periods X dollars per day. It changed because of LIBOR, and then you just added the math. The way that it appears to me in the affidavit is you owe X in principal and Y in interest because I say so. Is that enough under the new summary judgment rule?
I don't think it's because I say so. It's because the documents, the business records say so. But yeah, I would agree that the affiant did not do a line by line calculation. I would submit that's not required. All that is required is a person with knowledge present the documents and testify as to what the balance is. If that's not correct, then it is incumbent upon the other party to come forward with some contrary evidence.
So you're stressing the burden shifting framework under Celotex?
I would think so, yes, Your Honor, because then that would then allow or permit then counter evidence to be produced in response to that. Until that point, there's no issue. in effect.
What does
Other
that look like in a LIBOR loan? If, for example, Mr. Felix would have appended to his affidavit copies of checks of every payment that he would have made and said, I total up this, and it doesn't resonate with your client's calculations, would that have been enough?
It depends on whether then there could be an explanation. We can show each of those checks and whether this, when and where this check was credited and the balance that resulted, including the application of that particular payment to the existing principal and to
Right,
the existing
right.
interest.
Well, what if he
Each
shows a
occasion.
check, say for, what if he shows a check that's made for $150 during a specific period that shows that your client endorsed it and that check doesn't appear on the payment history? Would that be enough?
That to me, without a counter evidence of an explanation, that would be sufficient to at least suggest that there's some inaccuracy in the accounting.
But what we have is basically a counter affidavit that says this loan history doesn't make a lot of sense to me.
That's what you have. And if that were enough to defeat summary judgment, I dare say that rare would be the summary judgment.
Anything more, Mr. Roth?
Well, yeah. I think I can conclude. I could address a number of other issues if I'm just looking at my notes right here. No, I think, based on the court's questions that, I think that the court's framed the issues and, as I alluded to in the very beginning, to me, I think summary judgment is proper based on the record. When we engage in what could have been or what might have been, I can't answer that directly because it's not, and the argument hasn't been, it wasn't presented or on the record. So then we move to, well, in the first instance, did the court abuse its discretion in determining that this was not properly before the court? And as I said, if the court did, then we go back. I know of no other way we couldn't do that, just because if all of that should have gotten in, we haven't had an evidentiary hearing on any of this. And so, but if the court did not abuse its discretion, I think summary judgment's appropriate and the case is done. Thank you.
Thank you, Mr. Roth. Mr. Pierce, you got about 2.5 minutes.
I'll start with one of the last questions that Judge Traver requested as far as the payment. In the request to produce, there was a request for payments whereby it could have been tracked. As I stated before, discovery was open. It was never noticed for trial. So with discovery, obviously, we would have been able to have determined that. I do not think that the appellee should be rewarded for not providing documents or being unable to provide documents.
Is the counter to that, though, Mr. Pierce, that the evidence of what your client himself paid is within the control of your client?
Not when there are two people. There were actually two people on that loan. And I wanted to make a determination of which payments were made and who made them. So there was another person there. So my client, they came after my client, that's fine. But there were two people on that loan. And if you look at my client's affidavit, it was clear that he wasn't certain that he made certain payments. So that would have had to have been the other person.
Yeah, he said he didn't make payments in 2016.
That's correct. But there were payments reflected. So obviously, I would need to get those in order to determine exactly how much was actually paid and how much should have been attributed there. He stated that there were running balances. There were not running balances, and they definitely did not reflect the LIBOR for each payment. Back to the calculation, there were no calculations. And I stated before, discovery was still open, so therefore we should have been entitled to that discovery, especially since it was relevant to all of the issues presented and the amended pleading. Again, he stated that he could demonstrate futility there was no futility demonstrated. They tried to raise that argument in the answer brief, and it was clearly addressed in the reply brief. The standard for summary judgment was not met. Summary judgment should not have been entered. The trial court abused its discretion in granting summary judgment in the face that discovery was still open and outstanding, that the matter had not been set for trial, and it was my client's first request to amend the pleading. And there was absolutely no clear evidence of prejudice, abuse, and futility. Therefore, the motion to amend should have been granted. We're requesting that this court reverse the trial court and send it back so that the motion can be resolved on its merits, so that the issue can be resolved on its merits.
All right. Thank you, counsel. Case was well argued. We appreciate your arguments.
Thank you,
and
Judge.
We are
Thank
in recess. Have a great day.